Good morning, everybody. Welcome to May's Employment Coffee Briefing. Today's session is going to be looking at discipline and conduct issues. Those of you who've joined me before will know that I like to try and get these sessions to be a little bit interactive, to try and engage with you all as best we can online. I know it doesn't quite compete with being in person, but we'll do our absolute best. What I thought I would do with today's session is condense down a training session that I've actually put together, which is designed to run an entire day. We do an in-house session looking at investigations and disciplinaries, which I've run 7, 8, 9 times for one of our large clients who wanted to get all of their managers trained in investigations and disciplinary processes. And I've run it a couple of times sort of through Fretton separately and opened that up for people to attend as well. As I say, it is actually designed as a whole day session exploring a case study. It's a really interactive one. It's great fun. But what I've tried to do is condense it down into an hour to focus on the key points. I still think it's useful. Obviously, it's targeted at people who conduct disciplinaries and investigation processes beforehand. And it also means that I'm a little bit law light today, which hopefully everybody will appreciate. Not a sales pitch. I'm not desperately trying to get you all to sign up to it. It was just a very easy way for me to put forward a session that I knew covered a lot of useful content. So we will look at both investigations and disciplinary processes today. The idea really is going to be, as always, just to flag some key concepts, some key ideas that I think are useful when conducting them, or indeed when advising on them or delivering your own training on them. So, without further ado, as I say, it is going to be a fairly interactive session. It will benefit us hugely if there can be some feedback either through the chat and the Q&A. If not the chat, then where it comes to on the Q&A, I will, as always, sort of read out comments as they come in. So let's start with the absolute basics on this. It's highlighted there as a discussion point because obviously when we're delivering this session in person, I make everybody talk about it. What I'm going to do in this session is try to make you engage and interact with me. Think about your workplace. Think about the businesses that you work for if you're a HR consultant or HR specialist, or as I say, think about your business internally. Just by way of throwing out some ideas here, let's give some thought to these 2 points because they're a helpful start points. What are the kind of issues that we're looking for? What are the situations that arise where you might be triggering a disciplinary process? And as an extension of that question, what to you is the distinction between misconduct and gross misconduct? Where do you draw the line? Where do you feel that there is a distinction? And this is the point where I'm either going to talk rubbish for a couple of minutes just to try and fill the gap, or sit awkwardly in silence while people actually find a reason to contribute. I do think this is an important start point though, because ultimately we're talking about initiating a process that could lead to somebody's dismissal. And so where we sort of want to start from is, what actually are we doing where we're triggering a disciplinary process, and are there things that we should be thinking about instead of running a disciplinary procedure? And of course, the distinction between misconduct and gross misconduct is important because they're 2 buzz phrases that we use and encounter all the time, but they're not necessarily ones that everybody understands, and certainly I would suggest most employees don't understand. So I'm starting to get some answers come into the first question now about disciplinary procedures. So poor performance, bullying, harassment, conduct issues, capability, capacity, high levels of absence, yet potentially. What else are we seeing? Yeah, specific examples, great. So I've got theft coming in there. I've got, what have I got? I've got dishonesty coming in there. Good. Yeah, I like being rude to customers. That's a nice specific example. I mean, I don't like being rude to customers. It's not to their face anyway. And what about this distinction between maybe misconduct and gross misconduct? Anybody got any immediate thoughts on that? So what we're thinking about that one, I'll start kind of giving my thoughts on the first one, really. A couple of people have mentioned sort of capability issues. fine, yes, they are potentially a disciplinary process, but by all means look back on last month's session looking at capability and performance questions. They're not always something that you're going to run as a rigid disciplinary procedure, because to me that there can be a distinction in capability and performance and a disciplinary process or procedure. And I think it's important to run the right one in the right circumstances. But yeah, most of these others, I mean, to me, a disciplinary procedure is going to be started where an individual's, I suppose, conduct falls below the standards that we expect as a business. Doesn't necessarily matter what that business is. The disciplinary procedure is designed to improve behaviour, I think, is probably the way I would look at it, perhaps over the others. Some of these answers to gross misconduct, we've got things that put the safety of other staff or clients' customers at risk. Yeah, anything that brings them into disrepute potentially. Serious offence to fire, misconduct to serious offence. Yeah. Anything illegal is gross misconduct. Yeah, okay. Happy with most of those answers. First place you're going to look for misconduct, gross misconduct, is either your policy or your contract or your handbook. There's probably a list of them. It won't be just an absolute list, you know, it won't be completely exhaustive and probably says it isn't. But your starting point as to whether the act that you're looking at from a disciplinary perspective is misconduct or gross misconduct is, firstly, what do we ordinarily call it as a business? The reason this distinction is important, though, to me, and somebody has picked up on it, gross misconduct, you won't find a legal definition of this, but it's one that's slowly developed and we've become more aware of. I think, to me, gross misconduct is something where you might, in some version of how this disciplinary process pans out, be looking at terminating the individual's employment. And the reason you want to decide this very early on, even if maybe you're not necessarily considering dismissal at this stage, and of course you shouldn't be, is if you've called it misconduct all the way through, and then you get to a disciplinary hearing and the disciplinary chair goes, hang on, this is really serious, I might want to sack this individual. Well, you haven't called it gross misconduct from day one. And there's an argument that the employee will not have been taking their defence of themselves as seriously for something which has been called misconduct and now suddenly is being faced with a dismissal. So to me, what you're doing at the very early stage is deciding the difference between misconduct and gross misconduct, obviously based on the actual behaviour itself. And the ultimate question is this a situation where I might be looking at terminating this individual's employment? If there's any chance that might be yes, call it gross misconduct. The question has come in, if you call it gross misconduct, can you backtrack to just misconduct? In a sense, yes, you absolutely can. The important distinction really is that any of your potential sanctions for misconduct are valid for gross misconduct. So you can still be calling it gross misconduct all the way through. You can still call it gross misconduct in the disciplinary outcome letter if you really want to, but you can still just give it as a warning, for example. The point is, what you're doing by calling it misconduct from the start is potentially cutting off your ultimate sanction, or certainly giving the employee the opportunity to call into question the fairness of the process if they've been treating it as, okay, the worst I might get here is a warning, and then suddenly it's a dismissal, gross misconduct. Okay, so that's kind of the distinction to me, and I do think it's an important one to be aware of, particularly where sort of this is being managed by line managers internally, and disciplinary processes, of course, often are. So process and procedure when it comes to disciplinary and investigations, it is relatively straightforward. It's about as simple as you would expect, quite honest. It looks like any other process that we might follow internally. You become aware of the issue, you undertake an investigation, which we'll explore in more detail. We'll talk a little bit about evidence gathering. There's obviously the disciplinary hearing at the end to actually decide what the outcome is going to be, and then delivery and imposition of that outcome. As I say, for the training session we run on this is where it starts to turn into quite a practical, let's walk through these stages following a case study. I'm not going to introduce the case study for the purposes of a 40-minute quick webinar, because it would take 20 minutes of those just to read it and understand all the facts. So what instead we're going to do is talk through some of the issues that arise when we're going through this process and procedure. Firstly, before we come to all of that though, let's think about some of the alternatives to the disciplinary process. And by all means, as I'm talking through these, if you want to chip in with your experiences, comments, or sort of thoughts on any of these, then by all means do so. To me, you should always be considering a process that, or a potential route of action that is not a disciplinary procedure. There's going to be situations where you've got absolutely no choice. Somebody punches a colleague, you're not going to have much option other than the disciplinary process. Somebody, commits a serious incident of theft, you're probably not going to have much option. But in some situations, and the big one I think to me is performance, as we discussed in last month's session, and also that kind of classic disciplinary issue you end up in where you've got two employees who just don't get on. There are means of resolving it that aren't necessarily a full disciplinary route for each person, and which don't necessarily carry the risk, of course, of an unfair dismissal at the end. So I've got, the first point there is something else might be a relevant outcome from an investigation report. And we'll touch on that a little bit more when I talk about investigations in a moment. But yes, it may well be, and it's perfectly valid for the investigator to reach the end of their investigation and say, well, actually, I don't think disciplinary is the right process here. I think there's something else that's gone wrong. I think there's something else that might work better. Why don't we consider this before necessarily going to a full disciplinary hearing? So I've suggested there performance management. Yes, there is a difference between your performance management process and a disciplinary. Please watch previous session on performance management if you missed it, because I do talk at length there the difference between performance management routes and the disciplinary procedures. Is this a management intervention question? So this maybe goes to the situation where you've got, it could be a performance issue. It could be, as I say, one of those examples of two employees who just aren't getting on. Is there the completely off the record, this is not official legal advice, equivalent of banging their heads together and saying sort themselves out? Is this just somebody who is slacking a bit? You don't need a massive disciplinary process to pick up on somebody who is arriving 5-10 minutes late every day. That first step is actually management intervention to ask what's going on, and to make the point that it's not acceptable, and unless there's a particularly good reason for it. It's not necessarily let's go through a formal process here. I've got change of procedure or policy there. That's an interesting one. I've had it crop up in an investigation I was advising on, where the investigation officer came to me and they said, look, I don't actually think that the individual has done anything wrong here. I think there's an issue with how the policy works or how our procedure initiates. And actually, if that's the case, it's a perfectly valid outcome. You don't put an individual through a disciplinary for fiddling their expenses if there's a fundamental error in the expenses reclaim form. That's the business's mistake. That's not the employee's fault. They're not necessarily trying to be dishonest with you, unless you've got evidence to suggest they are. So it is perfectly valid to, as I say from the investigation report, go, hang on, this isn't the employee doing something wrong necessarily. And then I've got mediation at the bottom. So this is the one where if anybody does want to kind of chip in with some immediate thoughts on mediation, please do be my guest, because I know it's a controversial one. And I know it's one that some people will say is fantastic because they've had a really great experience of it. And some people will go, yeah, it's just a way of wasting money on a mediator to come in and have a chat with people, and then we've still got the issue at the end. I've known some I've not personally been involved in a mediation in the workplace other than sort of the judicial mediation process through the tribunal. But I have known examples from talking to people of some pretty extreme A and B don't get on that is actually resolved through mediation. So I think it is always something that is worth considering, and always something that is worth having in the back of your mind. Least of all because if it resolves, if you get these two employees, and keeping this example of it being two people who have just fallen out, if it resolves, if you get them working together effectively, if a solution can be found, then actually, why not? You've avoided a disciplinary process, you've avoided a potential unfair dismissal, you've avoided a potential legal claim and the associated costs. And let's not forget, it costs enough just to defend a claim. You've got to pay me to do that, that you might lose. And I always think, and I'll always say it about these processes, it's exactly the same as sickness absence, it's exactly the same as performance. If there is a way that it can be resolved internally, then do so. I absolutely accept that not all cases are going to be appropriate for mediation. More serious gross misconduct situations, almost certainly not. You're not going to mediate theft, dishonesty, assault on a member of the public. That's just not an option. But there are many situations where it is going to be a potentially viable alternative, and it can work. Query here, should management intervention be put in writing or is it just verbal? Classic lawyer answer, I'm afraid. It depends, because you don't know at the point when it happens where it's going to go moving forwards. My suggestion would be, you're not necessarily going to write to the employee and say, I've given you this warning about you being late, because that starts to look like the implementation of a formal process. My advice is always going to be document that the conversation has happened. But I think you're doing it in a way that doesn't look too formal. So let's use the example of, you picked up that 1, 2, 3 people are consistently late into the office. There's a few ways of managing that, isn't there? Option 1 is an all staff email that says, look, everybody, we have noticed this. Just be aware that your time is, your day starts at 8:30. You're expected to be there and ready to work at 8:30. That's not the same as turning up at 8:30, getting a cup of tea, getting your breakfast and starting work at 9. That email is then there. It's not directed at anybody specific. It's not a formal process, but there's evidence that you have highlighted a concern so that if you have to go down a disciplinary route with an individual later, it's already been there. If it is one particular issue, it may be something that you've addressed as part of performance management or an appraisal anyway. To me, if that conversation has happened and it hasn't initiated a formal disciplinary process, then you are documenting it in the same way you would document any other management conversation. And if managers are talking to their staff about something, yes, to me, there should be a record that something has happened. Does that answer the question? Brilliant. Okay, moving on from alternatives, let's just touch on the law very, very quickly here. And it's about the importance of fair process and procedure when we're going through a disciplinary. The legal claim that we're at risk of here is, of course, an unfair dismissal. It may well be that your outcome from your disciplinary is to terminate the individual's employment. If they've got under 2 years service, this ordinary unfair dismissal claim is not going to exist for them, as we all know. Watch this space, because Labour have said they might change that, but at the moment the law is under 2 years. You don't have an ordinary unfair dismissal claim. From my point of view, just as a brief segue, if you are running a disciplinary process for someone under 2 years, I would still suggest doing a very, very condensed version of it. It's not necessarily a 2-week investigation. It's not necessarily a formal disciplinary hearing, but I do think it's a good idea to put an allegation to them so they're aware of why they're being dismissed, rather than just giving them a letter that says you're dismissed. They might not have a legal claim, but it just saves them off doing anything difficult afterwards, quite frankly. They might still talk to ACAS. They might even still try to issue a claim, even though they don't have the 2 years service. You've still got to deal with that. But let's assume we've got an employee who does have 2 years service. A dismissal can be unfair in one of 2 ways. It can either be factually unfair, where you haven't established your reason for doing so. That is one of the 5 reasons set out in the Employment Rights Act, one of which is conduct. So you have to reach kind of this threshold of having reasonable belief that the person has actually done the thing you've accused them of, and that it amounts to gross misconduct. It's only reasonable belief. I'll come back to the burden of proof shortly, but it is only more than 50%. And a dismissal can also be procedurally unfair. So that's where the entire process is tainted. And as I've said there, this applies to the entire procedure, not just the final decision. So a dismissal can be held to be unfair because a procedural irregularity was highlighted during the investigation stage, which is then not somehow remedied at final disciplinary hearing or as part of the ongoing process. And in either of those situations, you do have the risk of an unfair dismissal. So therefore, yeah, it does apply to the entire process. It does apply to the entire procedure. So you need to be aware that anybody who is engaging in this process, either as an investigator, as the disciplinary chair or as anybody else, is aware of process and procedure and is aware of the minimum standards. And again, not to keep harping on about it, but that is why this one individual client wanted us to go in and deliver a full 6-hour day training to all of their line managers, and it's something we do on a routine basis for them. Right, back to you for a moment, and let's start thinking about the initial stages of this. We've got an investigation process that's initiated. I'm not going to ask any of you if you've ever been under investigation for a disciplinary offence. I would assume nobody on this call has ever done that because we're all wonderful people. But put yourself in the position of someone who has been accused of gross misconduct, and maybe just by a couple of words, a short phrase, buzzwords that would maybe come into your mind here. What would you want from an investigation? What would you expect that to look like if you were the person who was being exposed to this process? As he sits in awkward silence for a moment, hoping lots of people give some answers. Okay, I've got transparency, confidentiality, fairness and timely communication, non-biased opinions, a fair chance to tell my side of the story, fairness and thorough investigation, clear evidence, an impartial investigator. Yep, fantastic. Anybody else? Any more for any more? I think we're probably covering most of them there, aren't we? Clear details of what I've done, clear evidence when it's been established. Yeah, absolutely. I think ultimately it boils down to a combination of those. I would probably suggest, yeah, fairness, impartiality, and knowing that you are going to be listened to and have your version of events taken into account. I think they're probably all very valid answers. I was delivering this session in-house once and somebody said that they wanted it, they used the word thorough, which is fair enough, but then went on to compare it to sort of a police investigation. It is worth pointing out that obviously there is a parallel here between a police investigation and a court case and an internal investigation and a final hearing. But the burden, the threshold, the expectation on you is significantly lower. You're not accusing someone of criminal offence and sending them to prison. Last answer that's just come in is like to know if I had support, and yeah, that is one that comes up occasionally when we're doing this training, and it's one that in-house HR teams have occasionally taken away when we've delivered this as well, and gone, actually, maybe that's the thing we don't do very well, is ensuring that the employee under investigation has a point of support. I'm not going to talk at length about suspension, but it will often be the case that you've suspended an employee and probably simultaneously told them they're not allowed to talk to anybody. That is incredibly unpleasant. It is incredibly alienating. So yes, to me, it is important that where appropriate, you give them someone who they can talk to, and that's not the same as the person who's going to keep in contact with them throughout the official process. And or signpost them towards employee assistance, EAP programs, if you've got them in place. But otherwise, yes. I mean, what do ACAS tell us that these should look like? There is a quote from the ACAS Guide on Investigations. If you haven't read it, do so. ACAS guidance on investigations, disciplinaries, and grievances are, to all intents and purposes, a minimum standard. Those of you who are using our policies and procedures, they will always be updated to ensure that we're complying with what ACAS are telling us to do. If you don't, then make sure that your minimum standards are at least what ACAS suggest. Going through the ACAS guidance, if it ever says that you should, or it's suggested, or that it's a good idea to do something, do it, because quite frankly, a claimant lawyer bringing an unfair dismissal claim will always try to find something that you've done wrong under the ACAS guidance. So what it says here is that an investigation is fact-finding. Yes, it is. It's not a decision-making exercise. It says all the relevant information. The tribunal will generally translate that to mean it's got to be a reasonable investigation. There's no kind of expectation here for you to collate every conceivable piece of documentation that might be available to you, because there is a balancing act to achieve here between what is a reasonable investigation and let's actually wrap this up within a reasonable time frame as well. Investigations that last kind of 4, 5, 6, 7, 8 months investigating a specific incident are going too far or taking too long. They're causing stress to everybody. So you will find some of this guidance is a little bit contradictory. There's an element of wrap it up quickly, but also this collect all relevant information. My advice is always the test you're put to is what is a reasonable investigation? What would a reasonable investigator do in your circumstances? It allows somebody to fully consider the matter and make an informed decision. Yep, so there's got to be enough information there for somebody ultimately to make a decision on what has and hasn't happened. And there you've got the risk at the end there. We've discussed legal action. Worth pointing out here, because I know some people know this, I know some people won't. Failure to comply with ACAS minimum standards can result in an uplift in the employment tribunal of up to 25% of any compensatory award. So just for the avoidance of doubts, if you do not do a thing that ACAS says you should do, and you are later found to have unfairly dismissed somebody, and they get awarded £10,000, the tribunal has the power to increase that by an additional 25%. Unfair dismissal claims are not always the most high value, but if you're going to lose one, you don't want to lose another 25% on top of that as well. So again, do check process, do check policy, and again, make sure that people who are running these procedures are aware of the expectation on them. Anything on that before I move on? Nope. Okay, obviously any questions, feel free to put them in, I'll always come back to them. Just a few comments on sources of evidence here. It's more things to be aware of than a comprehensive exploration of them. Your primary evidence in most cases is going to be witness statements. That's not unusual at all. It's true of the tribunal when you get there, to be quite honest with you. There's very rarely much else, and the primary evidence is what somebody has seen, has heard, was told. When you're taking witness statements as an investigator, I always like to start with sort of quite open questions. Your job as an investigator is to establish who, what, when, why, where, and how. That's your primary focus. You start by getting people to tell you what they know in very general terms, and then start going with the specifics. But equally, you know, bearing in mind you don't want a 20-page witness statement from somebody. You don't want to be taking 20 pages worth of notes when you're talking to someone as a witness. Other things to consider: forms of documentary evidence. It's going to depend on the case what is and isn't relevant here. If you're talking about some kind of financial issue, then there's probably going to be documentary evidence somewhere. Email exchanges are an obvious classic these days, WhatsApp messages, texts, those kind of things. And you can, of course, end up these days with a huge amount of information that comes out of documentary evidence. And again, this is one of those situations where you get this sort of conflict between what is reasonable and what isn't. What you know, should you be paying attention to here? Does an email from 18 months ago between the line manager and a third party actually become relevant to what you're talking about today? Unfortunately, as an investigator, that is for you to decide. I've got CCTV on there. I suppose the big one with CCTV is to be aware of two things. Where did it come from? And is there a data protection obligation issue? Too much for me to go into in too much detail now, but bear in mind that CCTV that is going to be used in a decision-making process like this should really be CCTV that the employee is aware of, and that they know that it could be used in disciplinary proceedings. The exception to this, and there is an exception under data protection regs about notifying and consent here, is if you suspect they've committed a criminal offence and you're trying to catch them doing it. So a targeted and specific surveillance that is done because you think somebody's putting their hand in the till and taking out 50 quid at the end of every day, you may well get away with doing that without consent or knowledge for obvious reasons. Before you do that, if you're ever considering doing that as part of an investigation, please take legal advice on the specific circumstances. You really don't want to get caught out with it as a potential unfair dismissal, and also get in trouble with the ICO. I've mentioned other forms of internal records there. Again, it depends on your business, it depends on the circumstances. If you work in a medical profession, for example, and your disciplinary issue is in regards to a patient, then their records are potentially going to be relevant if this is about a medication issue or a lack of care. Similarly, in our profession, of course, you may well be facing a disciplinary issue because of how you've conducted a client matter, so of course the client file becomes relevant. I've got a question on witness statement. I always love a question that starts, I'm sure this is completely irrelevant. It probably isn't. Don't ever feel like you're asking an irrelevant question. If you're thinking it, someone else probably is. With witness statements, does it matter if it's a witness statement written by someone else, or does it need to be a witness statement written by myself interviewing the witness? Yeah, you've got two choices there. I've got no huge objection to either. It's fairly common to send an email to a witness and say, can you just tell me what happened, or can you fill in this form that we've got as a standard witness statement or whatever. No particular issue with that. It's then up to you as the investigator to make a decision as to whether you need to interview them further to draw out more information. The problem with doing witness statements, and I'm now kind of talking from a legal perspective and having done it for clients, is if you say to somebody, write me your witness statement about what happened, you're going to get one of two things back. You're either going to get 3 sentences that said, I walked into the room, I saw A punch B, and I walked out again, which is potentially helpful. It tells you what happened. It doesn't really tell you anything else. Or you're going to get a 20-page document that tells you the entire life history of both A and B and the interviewee's personal history with both of them. And that's not much use to you either, because you've then got to read it and work out what's relevant. My general approach to this is, yes, get that very initial statement from them, because then you've got a very clear contemporaneous account of what happened. If you're then going to do notes of an interview, or you're just going to do notes of an interview, that's absolutely fine. There's no expectation on you to make the notes of an interview absolutely verbatim. There's no obligation on you to record them. What you need is the witness to then obviously sign those notes if you're preparing them and say, yes, this is an accurate account and this is what I said. Don't forget, if this goes really sour, the investigator, the decision maker, and potentially individual witnesses could all be called to give evidence in tribunal. You're going to want to make sure that what they're telling you at a very early stage matches up with the evidence they're giving in court. So to answer the question, no, it doesn't matter who it's written by as such, but it has got to be an accurate account from the witness's perspective. Are we happy with that? Fine. Again, if there's a follow-up question from that, I'm obviously more than happy to pick it up. Outcome of investigation, of course, is going to be some kind of report. It is going to be a document that collates all of the evidence and is designed to assist the decision maker in then knowing what's in front of them. So an investigation report, as I've said on the screen here, will identify any uncontested facts, so things that both parties agree is true. We were both at work that day, we met in the canteen, etc., etc. Identify contested facts, and then I've said there what happened on balance of probability. So this is your ultimate test all the way through. What do you think as investigator is more likely to have happened or not? And then ultimately as decision maker, what is more likely to have happened or not? So your contested facts are probably going to be A squared up to me first. B, A is obviously going to say, no, I didn't. B approached me, and then we got into a fight. Your job is to look at the evidence around that and try to reach a conclusion as to which of those things you think is more likely to have happened or not. But don't forget, as the investigator, it's not your job to highlight guilt. Your answer to that is, based on the evidence I've seen in front of me, I think it's more likely that A approached B and initiated contact. Beyond that, if you can't establish what happened, then say so. That's just as useful to the decision maker at the final disciplinary hearing if it goes that far, to know what you've not been able to figure out, because then they know what they've got to target as part of their questioning and investigation of the evidence. I've just had one other question. If the witness disagrees to the notes, but both you and the note taker agree with the notes, yes, this is a classic, and I'm assuming you mean it's usually the person under investigation themselves. You will probably end up in a situation where they want to put forward their own version of the notes. Both go into the investigation report, and it's for the decision maker to conclude on that basis. If you and a note taker, if you've got an independent note taker in the room, both of you agree with the notes, it's probably going to be said that the notes you've taken are accurate. But again, the onus is not on you to make them verbatim. As long as it's a reasonably accurate representation, there shouldn't be a major issue with that further down the line. somebody under investigation who is going to be dismissed is always going to look for something. Of course they are, quite understandably, and if that is disagreeing with the notes of your meeting with them, you can see why they do that. That investigation, I mean, those investigation notes are important. They're not going to be the deciding factor. So yeah, you can, you write to them and you say, look, as far as we're concerned, this is an accurate record. We'll put it in. If there's specific bits you want to annotate or you disagree with, then by all means, produce your own version and we'll include them in the investigation report. It shows that you've at least given them the opportunity to present their version of events if they don't agree with it. So disciplinary hearings themselves then, let's park the investigation for a moment. And as we said earlier, all kinds of recommendations can come out of an investigation report. There's nothing wrong with saying that there's no case to answer. That's a perfectly valid outcome. There's nothing wrong with saying this isn't the individual has done something wrong. This is an issue with process or procedure. But in most cases, the outcome is going to be either this allegation has a case to answer and should proceed to disciplinary hearing, or this allegation doesn't and there's no need to proceed. So we then get to disciplinary hearings. As the person who is then conducting the disciplinary hearing, so for the purposes of the training session, this is where we would flip hats after lunch and start thinking about ourselves as a disciplinary chair. What is it that you want to see, know in advance? Would you want a good investigation report? You want an investigation report that does all of those things that ACAS indicated it should, gives you enough information to make a reasoned decision based on what's in front of you. There are probably going to be questions that you've got for the individuals concerned because not everything will be in there. There may still be grey areas, but ultimately the investigation report should get you 90% of the way there if it's been conducted well. I've mentioned preparation here. I could have mentioned preparation on slide 1. All the way through this process, as the investigator, as the decision maker, you've got slightly different objectives, but you do want to stay in control of the process. You know what you're investigating, you know what you're deciding on. So there is nothing more important than making sure your preparation is clear in establishing what it is that you want to find out. The last thing you want is to be underprepared going into a disciplinary hearing and the employee under investigation in the middle of the hearing says, yeah, but what about the email I sent on the 14th of June? And we haven't got it, but they mentioned it in a statement and nobody's looked into it. So if there are gaps in the investigation report that you can go back to the investigator and ask about, do so. It's much better to delay the disciplinary hearing by a couple of days and ensure you've got everything you need in front of you than to have to suspend it in the middle because something that should have been looked at earlier hasn't been. I've asked a final question at the end there, and by all means, please yes, no me on this, because the answer most people come up with is it depends on their level of experience. But I've said, is a script helpful at any time? And we can think about that both from the investigation meetings point of view and the disciplinary hearing. People often have mixed views on this, so I'm curious, I should have set it up as a poll really, but you're about to conduct a disciplinary hearing. Are you potentially going to have a script in front of you? There's always one who caveats their answer, isn't there? Yes, yes, but a brief one. Yeah, I'm getting the answers I was expecting. Yeah. Yeah, a script at the start to make sure that people are aware of the things they're saying at the beginning. Hello, I'm so-and-so, we're here conducting this meeting, the people with us are A, B, and C. I do think that's potentially quite useful to scripts to ensure you don't miss anything out. And again, yes, at the end, thank you everybody for coming. Is there anything else that anybody wants to say? If not, we'll adjourn and consider our decision, etc., etc. They're probably both quite useful, as I say, just to ensure that you're not missing anything out. In terms of the substantive bits, what I usually do, admittedly, this is someone kind of experienced in interviewing clients and conducting hearings and those sorts of things. I like a table with the questions in it, and it doesn't matter whether I'm the investigator or disciplinary chair. I would probably do it in exactly the same way. I like a table with the things that I know I want answering, and we'll fill it in that way. Probably hand scribbled notes, just summarising the answers as they go through. Which I think is fairly consistent with what most people are saying here. Key points to cover, potential guideline, because obviously it needs to be adapted to the situation. Yes, of course, the basic questions, just as prompts. You never know where it's going to go. but it does help you, I think, to guide the conversation in the way you need it to go if you've got a general idea of the questions you're going to ask or the approach you're going to take. Yeah, good comment there. Scripts are useful as a summary and can form the basis of the minutes. Exactly. You take scribbled notes as you go through, turn that into a slightly more comprehensive note, and actually that's your account of the meeting. Just by way of quick poll, out of curiosity, investigation meetings, perhaps investigation meetings in particular, maybe more so than the disciplinary meetings, does anybody record those? With a sort of audio recording, or if you do it on Teams using the record or transcription function there? I'm expecting mixed answers on this. Yeah. Yeah. Okay, that's interesting. Yeah, I'm getting mixed answers there. I'm always curious. Just to answer the one question from a GDPR point of view, because that's come up as a question there. We don't use it because we weren't sure about GDPR. Yes, you can absolutely record them if you choose to do so. The GDPR issue is simply make sure you got the employee's consent to do it. And yes, that's a worthwhile point as well. A colleague explicitly asked the employee not to record. That's always an interesting one. The Employment Tribunal's position on covert recording by an employee is that's very naughty. You shouldn't have done it, but we'll listen to it anyway because it's relevant information, usually, just so everybody's aware. So therefore, what you want to do to best protect yourselves in that situation is two things. You want to adapt your disciplinary policy to make it clear that covertly recording a meeting without consent is a gross misconduct offence. Because then if you get to the end of this process and you go, oh, there was an unfair dismissal claim here in relation to where you punched your colleague, but are awarded an unfair dismissal claim, you then get to turn around to the employer and go, well, hang on, but they covertly recorded the meeting, and that's where the evidence comes from. We could have sacked him for that anyway, and that might help you. The other thing you want to do is, obviously clearly make it clear that the employee shouldn't be recording. If a recording is being done, it's your version. You can absolutely ask them to leave any device that could record outside. But yeah, the first one in particular, just adapt it to make sure it's in there because it might help you if you do discover that employees covertly recorded a meeting. I think my view on these generally is there's no need to record them. There's no obligation on you to make a verbatim account. But if you're comfortable that you're not going to say anything wrong in that meeting, then I don't see a huge issue with recording. My biggest issue is transcriptions of recordings. Teams transcription is wonderful if you speak with a perfect accent, preferably received pronunciation, and it's picked everything up wonderfully. But what most of you will probably find if you've used it is you end up with 20 pages of ... and then it usually can't pick up on what somebody is saying, even if they've got the slightest bit of an accent that's not either generic American or received pronunciation here. That's what I really don't like about it. You then spend hours going through it. Okay, useful. And useful answers, thank you, because we do get a mixture of yes and no's there, which is what I was expecting. Okay, let's talk briefly about the right to be accompanied at these meetings. It is a statutory right. People are generally aware of it. There's probably a line in your letter that would say something like, you have the right to be accompanied at this meeting by these types of people, and then we sort of forget about it. So Section 10 of the Employment Rights Act tells us that a worker who is required to attend a disciplinary hearing, particularly one at which the outcome might be dismissal, must be permitted either, I've said an employed TU rep, an internal TU rep, or a colleague there. It is technically the three of them. By employed TU rep, we actually mean kind of a TU official, so somebody from the trade union itself. An internal TU rep is obviously a colleague who is also a trade union representative, or another colleague. And the statutory right is those three. If they're not a member of a union, tough on the first two probably, because they may find they don't get assistance. And if there's not appropriate colleague to attend with them, tough. They're not technically entitled to the statutory rights. But question at the end there, or two questions. Do you allow anybody else, either by policy or discretion? If so, who? And is there anybody who you absolutely would not allow to be in that meeting with them? See what comes out. I'm expecting some mixed answers again now on this one. Yeah, absolutely right answer. Never, ever, ever allow a lawyer in that room. The first two answers I got were basically never let a lawyer in. It's absolutely true. Simple reason, you don't want a lawyer there on either side, really, if you can avoid it. You don't want the employee to have a lawyer, obviously, because with all due respect, they will just be trying to get one over on you as the person conducting the meeting. And actually, you don't necessarily want a lawyer on your side either, because let's say I'm acting for the claimant and I know that a lawyer has sat on the panel as the decision maker. I'm absolutely going to call that lawyer to give evidence in tribunal. And then suddenly that lawyer is stuck between their duty of confidentiality to you and their duty to act in your best interests and their duty to the court to talk about what actually happened in that hearing. Basically, if you're going to have a lawyer there, quite frankly, you might as well have the two lawyers having a without prejudice conversation to try and resolve it. A few other people then. Who else do we potentially allow? Yeah, anybody where it would amount to a reasonable adjustment to allow them. So if the person, maybe their English isn't fantastic, allow a translator in with them. Parents for a young employee, yeah, particularly if they're a minor. I would suggest you need to allow them to have an appropriate adult with them potentially as an additional person there. Parents are always an interesting one. I'll come back to in a moment. Yeah, mostly covering reasonable adjustment, somebody who's got a disability as well, who may need a mental health advocate, for example, with them. That somebody would obviously be appropriate. I've had someone ask to bring the person who raised the initial complaint about them to the meeting before it was in there. Yeah, funny that. Can't imagine why they would want them there for the disciplinary hearing. Potentially as a witness, bear in mind if they are at the disciplinary hearing and they want to ask questions of a witness, that is something they might be entitled to do, but no, certainly not as the person to accompany them. That seems very weird. Yeah, parents, always an interesting one. We know what mum and dad can be like. They can become a problematic a sort of accompanying person. Can be difficult to deal with, but at the end of the day, my view on this is allow anybody that's going to help the process. You know, because what you don't want is somebody who gets stressed, wishing they had moral supports in the middle of that meeting and doesn't. Then it gets postponed, then it gets suspended, it has to be reorganized, etc., etc., etc. Providing they're not disruptive to that meeting, providing they're not giving legal advice, providing they're not a lawyer, my view is basically allow anybody who it might be reasonable to allow in there. There's no legal obligation to do it, but if it helps you run the process more smoothly, I have no particular objection. I don't see why you wouldn't. Very quickly on outcomes and outcome letters then, the big point there is the big one in the middle. Outcome letters should be written by the decision maker. The number of outcome letters you get that have clearly been written by a lawyer or somebody in HR and then just signed by the decision maker are incredible. No particular issue with that, providing the decision maker understands it and knows that letter like the back of their hand. And the reason I say that is because if it ends up as an unfair dismissal claim in tribunal, it's not the lawyer or the HR consultant or the HR director who's going to be called to give evidence. The decision maker is going to have to justify their decision. And there is nothing more awkward in an unfair dismissal claim than pointing a decision maker to the letter they've allegedly written. Do you recall writing this? No. That is going to be problematic for you. It's a procedural issue. It suggests that the decision was made by somebody else. It's going to start to go sour very quickly. So I've said it should be written by the decision maker. It should absolutely be written with their involvement. They should be familiar with it. They should understand it. And it should sound like it's been written by them. Your basic conclusions: who, what, when, why, where, how. What happened? What has been established? What hasn't been established? And make sure that in that letter we're covering the actual decision. I'm upholding the allegation of gross misconduct against you for allegation A. I am not for allegation B, etc., etc. The reasons for this are the findings from the hearing. This is what I have concluded took place on the evidence presented to me. The outcome of this is that we are terminating your employment with effect from date without notice, etc., etc. Any further steps or recommendations they might want in there? So it might be that the outcome is not dismissal, but it could be a written warning, and that's where you're going to put in your This warning will stay on file for 6 months, and a repeat of this or a similar allegation may result in gross misconduct dismissal. And always put in a right to appeal. ACAS say they should have one. If you don't put it in there, it's a very easy way to get an ACAS uplift against you if you win. Always give them the opportunity to appeal. They do have the right to do so. Doesn't have to be a huge amount of time. 5 days to lodge their appeal is probably going to be reasonable unless there's a discriminatory reason to the contrary, but put it in there. Okay, finally then, and I'll tackle questions. I've just seen one pop in when I've just run through this slide quickly. The legal risks here I touched on earlier. An unfair dismissal claim, the basic award is exactly the same calculation as statutory redundancy. The longer somebody has been there, the higher their basic award will be. The tribunal has the power to award compensation that is, to all intents and purposes, a year's salary. There is a cap on it that is over £100,000 now. For most people, realistically, it's going to be a year's salary compared to that figure. Realistically, what the tribunal will do is award a compensatory amount for the realistic time that somebody has lost earnings or could have lost earnings. If somebody gets a job within sort of 3 weeks of leaving, that is going to be drastically reduced. That said, the one bit of good news in all of this, I think the legal burden in unfair dismissal falls slightly on the employer's side. And the reason I say that is because unlike discrimination, where I think employees are often given the benefit of the doubt to an extent, it flips the other way slightly for you. As I said right at the start, the test is ultimately, did you have a reasonable belief that the thing had been done and that it amounted to gross misconduct? On the evidence you've got in front of you from a reasonable investigation, have you concluded rationally that this could have happened and that gross misconduct is a potential outcome? The test for the tribunal that has been in place for years now is dismissal in the range of reasonable responses. Okay, the tribunal is not allowed to look at your outcome and go, oh, we think that's a bit harsh in the circumstances. They can't substitute their own opinion. If they can conclude that another employer in the circumstances that you were in, with the evidence you had, might have dismissed, that is enough. And it does make unfair dismissal claims quite difficult when they're run, when the actual disciplinary process is run reasonably well. Not to say there's not a risk. Somebody who's been there for a long time and then doesn't get a job could have quite a significant award. You've also got to pay to deal with the claim, of course, plus reputational damage and all of those things. So do try to avoid it. But you know, there is that slight caveat that this is slightly on your side. The question I was about to come back to then, what do I think about a demotion as an outcome of a disciplinary? It's a perfectly valid one. There is absolutely no reason not to use it. I always think that an employee is sometimes going to see that as worse than a dismissal. And it's all about the perception for them in that situation. It's obviously not going to give rise to an ordinary unfair dismissal. It may give rise to a breach of contract claim. So if you're going to use demotion, then make it clear in your policies that you can do so. The risk, I think, ultimately is that the employee reacts badly to that, resigns, and then tries to bring it as a constructive dismissal claim. In that situation, I think it's actually slightly harder for the employee to do that. But no, I don't actually object to it as a potential outcome of a disciplinary. And it shows that you've sort of satisfied that test of considering things less than dismissal, which is still in there as well. You know, we didn't dismiss, we did impose this alternative outcome. There are even ways, if you want to include it in your contract, that you know, loss of bonus, loss of benefits, loss of seniority are all perfectly valid outcomes to a disciplinary. There are plenty of options beyond warnings and dismissals. Any other thoughts, questions, comments from anybody? I'll just flag up the last page while we're thinking about that. Next session, I'll come back to questions after I've done this page quickly. Next session will actually be the 12th of June because I'm on leave the first week of June. We'll look at family-friendly rights, including some of the big changes that have obviously come in the last few weeks and that are changing this year. So let's think about some of these questions. It is just coming up to 11 o'clock, so I appreciate if anybody wants to sign off, you're more than welcome to at this stage. I won't be offended, but I will start running through the questions with the view to finishing about 5 minutes. Do all claims taken to tribunal get heard, or if the employee has refused to engage in mediation, there's clearly no merit in it, can a judge refuse to hear it? Yes, so when a claim is issued in the tribunal, it goes through a vetting process. There is an initial sift that's usually done by a legal officer in the tribunal. They're not necessarily a judge themselves. They're often not even a fully trained lawyer. What they will look for is there a statute bar to the claim? So the only thing they'll do is, it's an unfair dismissal claim. Did the employee have 2 years service? It can fail at that point, and a judge can strike out kind of straight away at that point, but it's rare. It's much more likely that the claim will be processed through, and then as the respondent, you get an opportunity to apply for a strikeout if there's no merits. There will almost certainly still be some kind of hearing to deal with that. Going back to earlier discussion on informal disciplinary meeting and typing up your own notes, should you give the employee a copy? Okay, so that's presumably going right back to what we said about kind of these sort of less formal management discussions. I think it depends on what you think is most appropriate in the circumstances. If you're doing a performance review for an employee, then you give them the notes of that meeting. If you've sat down and said, look, we're just raising this as a potential cause for concern, I really do think it depends on the circumstances and the exact nature of the issue in question. The tardiness example I gave, I probably wouldn't. I would probably just have it recorded somewhere that I had that conversation with the individual, because once you start the disciplinary process, then if you're going to start a disciplinary process, it'll be triggered by a new event. You can pull in the fact that conversation had happened previously as part of your evidence. You're probably not going to be dismissing an employee for a few sort of late appearances anyway. And then the formal record of it is going to be the warning that you put in place as the outcome of that disciplinary, I would have thought. Anybody got anything else? Because if not, we're just about on time for 11 o'clock. And unless anybody else has got anything for me, I will say enjoy your day, enjoy the rest of your week, enjoy the month, and I'll see you in the first week of June, everybody.